The Supreme Court will decide before next summer the most important case for American democracy in almost 2.5 centuries since America's founding. That's a quote from retired conservative judge J. Michael Ludwig on the consequences of a court case that could upend the foundations of our republic, and the arguments have already begun to be heard. My last video regarding the subject of elections was certainly argumentative, but my main goal was to try and present a balanced view of a complex issue that both parties were guilty of exploiting. However, although the outcome of Moore v. Harper could potentially be used by any politician, party, or organization to obtain power, this case is very clearly a blatant attempt by the Republican Party specifically to undermine the United States Constitution. Indeed, nearly $90 million has been spent for conservative legal groups to file opinions in the court in support of a dangerous legal precedent called the independent state legislature theory. My goal for this video then is to help you understand the background of this case, the origins of this so-called legal theory, and explain why it is potentially an existential threat to the United States itself. Now, before we jump right into how insane and absurd this case truly is, it is important to first understand its equally dubious origins. As Peter Stone's article in The Guardian explains, quote, "The genesis of the Moore v. Harper case was a ruling by the North Carolina State Supreme Court in early 2022 that invalidated districts drawn by the Republican-controlled legislature on the grounds that they were an egregious and intentional partisan gerrymander, unfairly favoring the GOP. Since there are essentially zero federal restrictions on partisan gerrymandering, it has been left up to state legislatures, and in this case state courts, to determine what does and does not constitute gerrymandering and whether or not such practices go against state law or the state constitution. Of course, as is relatively predictable, one of the Republican state legislatures appealed the ruling in hopes that it would be overturned. Now, in a just and sane world, this would be the end of the story, as the Supreme Court would have simply refused to hear such a case in the first place, and yet here we are. So how exactly did we get here, and who or what is behind all of this? Well, as has been established, tens of millions of dollars have been pouring into the creation of amicus briefs for this case from countless conservative legal groups. For those of you who don't know, an amicus brief is essentially just an expert opinion submitted to the court by a third party regarding a specific case. Moreover, one such entity that submitted an amicus brief was an organization called the Honest Elections Project, who, on the front page of their website, state that, quote, "It should be easy to vote and hard to cheat." I'm sure that this isn't just an overly vague and agreeable statement to draw people in who may eventually support your cause without fully understanding it, except that's exactly what this is. In fact, one of the founders of this organization is none other than a man named Leonard, who is co-chairman of a conservative legal organization called the Federalist Society, which has a long history of pushing for conservative judges and justices to serve on the bench. What's more is that Leo also directly advised former President Donald Trump regarding the appointments of Justices Gorsuch, Kavanaugh, and Barrett. It should come as no surprise then that the Honest Elections Project also has a history of pushing for, quote, more restrictive voting laws. Indeed, as Hansi Lo Wang from NPR explains, quote, "In 2020, the Honest Elections Project submitted a legal brief in support of Pennsylvania's Republican Party, which unsuccessfully brought to the U.S. Supreme Court a case over whether a state court can extend the deadline for receiving mailed ballots. Thankfully, the state court concluded that the deadline had to be extended in order to prevent the disenfranchisement of voters, especially due to the complications with the U.S. Postal Service experiencing delays from the pandemic. Without such a ruling, it is safe to say that many voters may have not been able to have their votes counted in the first place, which is why the court stepped in with this legal remedy. However, as we all know, conservative organizations like the Honest Elections Project have not given up on voter suppression measures and are very blatantly seeking to prevent state courts from having any oversight whatsoever over state legislatures so that next time they will have no one left to stand in their way. In fact, another crucial figure in all this is a man named John Eastman, who you may very well recognize. You see, Mr. Eastman is one of the lawyers that tried to help Donald Trump overturn the 2020 presidential election through the use of the same legal theory that lies at the center of Moore v. Harper. While at the time he thankfully did not succeed in the courtroom, there's no guarantee that the same thing will happen for this case specifically. Additionally, it is also relevant to note that he also refused to provide the United States House of Representatives with over 100 requested documents relating to the January 6 committee's investigation. Hopefully, all this has provided a sense of the character and intentions of the individuals behind this outright travesty of a case. It is important to understand that this has been a concentrated effort by organizations like the Honest Elections Project and the Federalist Society and people such as John Eastman, Leonard Leo, and countless others to cling to power and erode our institutions, as this video will make quite clear. What's at stake here, however, is not just merely a question of technicalities regarding North Carolina's redistricting process, but rather something much more sinister that would change the way that elections could be conducted in an alarmingly large number of states. This is due to the fact that the very core of Moore v. Harper is linked to what is known as the independent state legislature theory, a theory that should have never made it to the Supreme Court in the first place. As retired Judge J. Michael Ludwig explains, quote, "The independent state legislature theory gained traction as the centerpiece of President Donald Trump's effort to overturn the 2020 presidential election. In the Supreme Court, allies of the former president argued that the theory, as applied to the Electors Clause, enabled the state legislatures to appoint electors who would cast their votes for the former president, even though the lawfully certified electors were bound by state law to cast their votes for Joe Biden, because he won the popular vote in those states." Essentially, the former president and his legal team tried to argue that states were allowed to completely defy the will of the people and send electors to vote for him instead to be president even though he lost. Luckily, this plan did not succeed, but as we now know, this has not stopped countless conservative organizations like the Honest Elections Project from trying to interfere with future elections. In fact, if they succeed with getting the ruling they want out of Moore v. Harper, the consequences will be dire. Indeed, this legal theory stems from a fringe interpretation of the first part of Section 4 of Article 2 of the U.S. Constitution, which states that, quote, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators." In other words, unless Congress dictates otherwise, states are free to set their own rules and regulations for running elections for members of Congress. While this appears to be simple enough, the issue here lies in what is meant by the term legislature. For quite some time now, the court has reasonably recognized that such a term does not merely just mean state legislatures on their own, but rather the legislative system and process as a whole for states, which includes checks and balances for such legislatures. However, proponents of the independent state legislature theory argue that the U.S. Constitution allows state legislatures to defy their own state constitution and state courts when it comes to setting election law. While the implications of this may not yet be completely clear, it is important to keep in mind that this sort of exception is not in place for any other type of law. As will become apparent, this case may set an alarmingly dangerous legal precedent that certainly should not be ignored. As such, it is important to dissect the key flaws at the core of the independent state legislature theory. As retired Judge Ludwig once again explains, quote, "Their textual argument is that the total disempowerment of state courts necessarily follows from the fact that the Elections Clause empowers the state legislatures to prescribe the manner of holding congressional elections." Once again, this is the argument that somehow state legislatures are uniquely immune to oversight from their own state constitutions and state courts when it comes to the creation and passage of election laws. This would mean that a state legislature would be able to do something such as extreme partisan gerrymandering even if such a practice is ruled by a court to go against the state's very own constitution or existing election laws. Because of this, Judge Ludwig rightly emphasizes that, quote, "Proponents of the independent state legislature theory go to extraordinary lengths to argue that the state legislatures have not delegated their legislative power to the state courts and are constitutionally prohibited by the Elections Clause from doing so. This, and their textual argument for judicially unreviewable legislative redistricting, are the fatal flaws in their argument. In other words, he is correctly pointing out the absurdity of allowing any state legislature from acting outside of the confines of judicial review, since there is not a single shred of evidence that the founders or the U.S. Constitution intended for such a thing to occur. As state legislatures themselves are given the power to pass laws by their state constitution in the first place, it makes no sense in the slightest that they would ever possibly be able to directly violate such a document. This would have monumental and grave implications for any and all elections going forward, and yet this case somehow made it before 9 of the most powerful people in the country. In fact, Leonard reiterates that, quote, "For where the proponents identify literally no evidence at all that the framers intended to foreclose state judicial review, there is actually overwhelming evidence in the text and structure of the Constitution and in the pre- and post-ratification history that the framers understood and assumed that there would be judicial review of the legislature's redistricting decisions. Indeed, the entire point of our system of government is that there are countless checks and balances on each branch, and while this may at times cause great frustration and gridlock, it is fundamental to our Constitution, and to simply cast this principle aside because your party didn't win an election is simply un-American." At this point in the video, you may be asking yourself what exactly the title means by "End of US Democracy" and whether I'm just being overly dramatic to get views. However, I genuinely believe that this is the most consequential court case of my lifetime, and I would probably lose sleep if I didn't make this video explaining how terrifying it truly is. Since I am no lawyer or legal expert, I'll let Judge Leonard explain the broader implications of such a case. Quote, "If the court concludes that there is such a doctrine, it would confer on state legislatures plenary, exclusive, and judicially unreviewable power both to redraw congressional districts for federal elections and to appoint state electors who quadrilaterally cast the vote for president and vice president on behalf of the voters of the states. It would mean that the partisan gerrymandering of congressional districts by state legislatures would not be reviewable by the state courts, including the state's highest court, under their state constitutions. This would mean that essentially any state legislature could not only massively disenfranchise voters through blatant gerrymandering, but ignore the outcome of presidential elections entirely. You see, in the United States, people don't actually vote directly for the president, which is beyond the scope of this video, but instead, state legislatures send electors to vote for president based on who won the electoral votes of the state. Technically, it would be allowed already for states to change their constitutions to make elections irrelevant and just pick the president themselves, which is also kind of terrifying to think about. But the outcome of Moore v. Harper could allow states to do so without even having to revise their state constitutions in the first place. I cannot stress enough how illogical this all is, since, again, the only reason that state legislatures have any of their powers at all is because they are granted to them by their state constitutions, and therefore it is unthinkable to imagine that they would somehow be able to just flat out ignore them. Indeed, it should also go without saying that this is the antithesis of how a system of government is supposed to work. For instance, the American Civil Liberties Union, or ACLU for short, explains that the framers fundamentally understood the power of legislatures to be drawn from and limited by written constitutions. They fought a war to break away from a runaway legislature, and they founded a new government based on the precept that legislatures and all government bodies can only act within the limitations placed on them by written constitutions ordained by the people. The suggestion that the framers trashed that fundamental principle when it comes to legislating the rules of democracy makes no sense. So, it was at this point in the video that I was supposed to give a short conclusion to wrap everything up, but of course some new developments have since occurred. Now that the North Carolina Supreme Court has flipped to Republican control once again, they actually overruled their past selves, giving the state legislature free reign over drawing blatantly gerrymandered districts. So, that's not great, I guess. However, this also means that there might not actually be a reason for the U.S. Supreme Court to hear the case anymore, but that isn't entirely clear. Regardless of what happens in this specific case, though, the underlying fact remains that the Republican Party is trying to do everything in its power to erode our democratic institutions, which is something that us citizens simply cannot ignore. Thank you very much for watching this somewhat bleak and overly complicated video, which was originally supposed to release like 3 months ago, and I hope that you have a wonderful rest of your day.